Board is now in session, and congratulations, Jim, on your United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all. We thank you.
Mr. Chairman, the first order of business this evening is appointments.
Okay.
And I believe this is a matter for the board Got
Okay.
it. The first item on today's agenda is appointments. This is the first meeting of the year. As required by local law and state law, the board chooses its chairman and council at this particular meeting if they so choose to make that decision. I'll turn that back over to the board, and you may appoint a chairman and a council to the board, as you see
At
fit.
this time, Mr. DeRusso, I'm going to appoint Adam Oshrin as going to be the vice chairman of the committee for this year, and Ron Schul to be our counselor for this year. And need an affirmation from the board.
Affirmation.
And we also, since it says appointment of chairman, we also vote to have Mr. G continue to serve as chairman.
I think that's part of the town board, no?
No, that's, the planning board appoints its own chairman.
Its own chairman, okay.
Yes.
All those in favor?
Affirmation,
Aye.
yes. Aye.
Opposed? So ordered.
Do you accept?
We will accept.
Congratulations, everybody.
All right. Frank?
With that, Mr. Chairman, and a Happy New Year to the board and to the audience, we'd like to turn now to the agenda and note that the following items on your agenda, noted with an asterisk, be adjourned this evening insofar as we have insufficient information for the board to take action tonight. Moving on to part 3 of our agenda, zone change applications, line 4, case number 2011-10, Anthony Lettieri. Line 5, case number 2011-01, All Seasons Motor Lodge. Line 6, case number 2010-06, KVC Holdings. Line 7, case number 2009-05, FB4 Realty Limited Liability Corporation and GMF Realty Limited Liability Corporation, and Town Line Road Enterprises Limited Liability Corporation. Moving on to part 4 of our agenda, line 8, case number 1059 Prestige Estates. Line 9, case number 1000A Soundview Estates. Line 10, case number 773 Scholar Estates. Line 11, case number 922 Sesame Estates. Line 12, case number 1053 Berg Estates. Line 13, case number 911 Glen Hill Northern. Line 14, case number 2, it's a 280A Olivia Estates, Birch Road. Item 5, on section 5, letters of interpretation, line 15, case number LOI-5, Polish National Church in Comac. Part 6 of our agenda, transfer of density flow rights, line 16, PR number 1, that's the number of it, and it's Brent J. Limited Liability Corporation. Mr. Chairman, those are the items the Planning Department is requesting for adjournment this evening.
Is there anybody here to be heard on those items to be adjourned? Hearing none, a motion.
Mr. Chairman, I'd like to make a motion to adjourn the items read.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered.
Mr. Chairman, I'd like to move back to the beginning of the agenda under Part 2, final applications. We have one case this evening under line 3, case number 1144, Esther Estates in St. James. Mr. Chairman, members of the board, the maps are before you if you wish to unfold them. The applicant requests final approval to subdivide a 1.992 acre lot into 4 single-family building lots. The map of Esther Estates was granted, case number 1144 was granted preliminary approval by this board on February 2nd, 2011. The final map complies with all the conditions set forth by the board. The proposal consists of one tax lot fronting on Lake Avenue that contains an existing two-story dwelling and 3 proposed lots to front on Lake Avenue and a proposed cul-de-sac to be known as Esther Drive. The site is split-zoned R21 single-family residence and R10 single-family residence. As noted in the preliminary approval, variances will be requested for the rear yard setbacks for lots 3 and 4 and to reduce the minimum lot area for lot number 3. Lots 3 and 4 are split zone between R21 and R10, with the front portion of the property is lying in the R10 zoning and the rear in the R21. Both lots do not meet the minimum rear yard setback requirement of 75 feet for the R21 portion. However, they meet the R10 standard. Additionally, lot number 3 does not meet the minimum lot area requirement for the 2 zoning districts. The average of both districts require minimum lot size of 15,065 square feet. Lot 3 is 12,710 square feet. The applicant is requesting a variance for a reduction in rear yard setbacks for lots numbers 3 and 4 from 75 feet to 50 feet and a reduction in lot area from 15,065 feet to 12,710 square feet for lot number 3. The board can grant these variants pursuant to Chapter 322-30.4 of the Town Code, and they will be listed in a table of modifications on the final map to be filed with the Suffolk County Clerk. The Engineering, Highway, and Traffic Safety Departments recommend approval. The Department of Environment and Waterways has reviewed this map and concluded that there have been no substantial changes to the project as originally proposed. Therefore, no further environmental review will be necessary. The Planning Department finds that this map is in compliance with the preliminary approval and that the variance requests meet the standards as noted in 322-4 in that it would not produce an adverse impact on adjacent properties. The request to reduce the front yard setback where more than 10% of the standard is confined to split zone properties that meet the R10 standards, that is in the front half, but not the R21 standards in the rear half. The appearance from the street view will be consistent of that of an R10 lot. 3, while the variances could be eliminated, they provide for a better design. 4, there is no adverse impact upon the environment. 5, finally, while the difficulty was self-created, the variances meet the other standards for variances. A recommendation. The Planning Department recommends approval of this final map and offers the following resolution for the board's consideration. Be it resolved that the final plat of Esther Estates, case number 1144, is hereby approved subject to the following conditions. Conditions A through H are standard conditions for all subdivisions with the following specific conditions applied to this subdivision. Item I, the submission of all necessary dedication papers, all applicable requirements shall be submitted by the subdivider to the Planning Department in complete and accurate form as one package at least 60 days before the expiration date of the conditional approval. Incomplete submissions will not be accepted. J, a fee of $175 is required for each lot that receives a variance from the requirements of zoning. And be it further resolved that the chairman of the planning board is hereby authorized to sign the final plat, thereby approving said plat after the town board has posted a performance bond of satisfactory form and amount. And be it further resolved that the conditional approval of said final plat shall expire 180 days after the date of this resolution and within 90 days after the chairman of the planning board signs the final map of this plat unless said office of the Suffolk County Clerk. If the board favorably considers the applicant's variance request, the Planning Department suggests the following resolution. Be it resolved that the Planning Board hereby modifies the building zone ordinance of the Code of the Town of Smithtown for the subdivision known as Esther Estate, case number 1144, as follows, which shown is a table of modification of dimensional requirements, and it's reducing the R21 requirements for the split zone properties from 75 feet to 50 feet. And lot number 3 from 15,065 feet, which, by the way, is an averaging of the 2 zoning categories. That's how it comes about. When you're split zone, you average the requirements, so the average is 15,000 square feet because the front portion is a 10,000 square foot and the back portion is an R21 standard. So the requirement under state law is that it be averaged. So the lot will be 12,710 square feet. This table shall be shown on the final map to be filed in the office of the Suffolk County Clerk. Mr. Chairman, that concludes the Planning Department's recommendation on this map.
Is there anyone here representing the applicant?
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I'm submitting the affidavit of posting to Frank DeRubius. And my client is here. We've heard the recommendations of the planning department, and we have no objection to the same, and we ask the board for its favorable consideration. Thank you.
Okay. Is there anyone here that wishes to speak on this application? Would you come to the microphone and give your name and address, please?
Hi, I got a little bit of a cold, so just please interrupt. My
You
name's
can even
John.
take the mic out of the thing if
My
you
name's
want.
John Danigelis, 9 Emery Drive. Daniggelis. We have, I talked to many of the neighbors in development, and we don't really have a problem, but nobody's seen anything about this until we saw the sign just recently. I know gentleman just said there was an affidavit of a sign posting previous to that, but we're all here for the first time. We don't know what the map looks like or any of where the houses look like or what the design's going to be. And, you know, that's kind of what we're looking at right now, just to get some sort of an idea of what they're planning to do. I mean, we've been living there for 20 years.
Anytime there that you see a property posted, you give Mr. DeRubis a call, and he'll show you any map that he has on file.
No, I understand that, and that's why we actually saw it posted. We went down there this week to find out that this is the final thing, and there was never a preliminary posting, unless it was on Lake Avenue and not on our street, which is, you know, the court that they're, you know, because the houses that they're planning on subdividing, I'm assuming, are the houses on Lake Avenue. So there may have been a posting on that side of the street, but this is the first we've seen of a posting on Amory Drive. My wife, we live right next to the lot, and again, we know that there was a planned thing down the line, you know, when we bought the home, but she's a stay-at-home mom. She drives up and down the block 1,000 times, and I mean, obviously, you can see the sign today. I should have taken a picture of it. You can't miss it. There was never, ever a sign before that. So we have no problem with something going in there, but we'd like some time to see what's going in there, and you know, I don't know what our options are at this point.
Well, we've already had the preliminary hearing, and this is a final.
Right.
So
So that's what I'm saying. I don't know how the preliminary hearing happened without a posting being made. That's my question.
we'll find out from counsel there what he did there for posting on the preliminary. You have to talk one at a time. We're all on television here now, and we have to have names and addresses so we can keep track of everything.
Can I take a look at the
Yes, you can look at that, and let me get counsel up here and then see if he can give you an answer for the preliminary.
I think we made him post this time, but if you take a look.
I have to go through this file, which is pretty thick, but I know we posted. We have an individual that does all our posting. His name is Tom Nally. I'll have to look through the file to see if it's here. If it's not, I'm sure that Planning Department has their copy, which would be the original copy of when it was posted. That's the best I can do. I'll go through the file while you're talking. I don't
Sometimes
know
there,
if
when the
Frank has a
postings
copy.
are done, you know, if you get a bad storm or something like that, I've seen that happen where sometimes the sign gets wet or something like that.
Well,
But
not the sign that's up there right now. The sign that's up there right now is plywood with a regular
yeah,
stage.
that's the way he usually does it.
Obviously, it'd be nice, it's posted beautiful today because it's approved, but I'm thinking that there wasn't a posting where it may have been on Lake Avenue where we didn't have time. And again, not that I'm against anything going in there, but if you see the driveway is gonna cut right on where I have the original plan of the house
We took a look
from
at
the original.
Well, this is this is already been run by engineering and the highway department there for approval before it was ever brought to us.
I understand that, but my point is that it looks like they're going to approve a street that's about 3 feet away from a driveway that runs up my whole side of my property, which is going to be an eyesore for me. And if they don't develop it right away, similar to houses up the street off of Jefferson Avenue that have sat vacant for 2 years where they haven't put a street in or able to build any homes, we wouldn't want that right in our development. This is town property on.
You have to go over to the mic, please.
I can talk louder. Sorry, maybe. The property obviously was, originally designed for that, and we've maintained it for 20 years. I have trees along the side. I could have left it as a town dump and not done anything with it, but there's sprinklers in there and all that, and it's graded, it's landscaped, there's trees along the side of my property, and I don't know how far the setback is from my property line now to any of this stuff, and that's why, like I said, not that we're totally against it, but there was never, I'm not saying there was never, but nobody's ever seen it, the sign that was posted up there, if it was for one day or not. I don't know how long it has to maintain up there or what the rules are, but obviously we see the sign today, or it was posted just last week. I don't know what the time frame is supposed to be on that, or maybe early this week. And we're all here right away, so it doesn't make any sense that we wouldn't have been here the first time.
Frank, do you have the
He has it
copy
right
of
here.
the original affidavit?
Yeah, he's got it right here.
That's our file copy.
That's the copy that the town maintains.
We have an affidavit of the posting, but like I said, sometimes people, for one reason or another, something happens to the sign and it gets, and it doesn't appear there, but we have an affidavit that it was posted. Now, that was for the preliminary.
How long is this sign supposed to stay up for the preliminary?
It's supposed to stay up there at
5
least there
days.
3 days?
5 days.
5 days.
5 days.
Yes.
And it should have been, who's supposed to maintain that the sign's up for 5 days?
The person that owns the property that's making the application.
So is there an affidavit showing that the sign was posted up for 5 days?
Yes.
They came every day and looked at that there was a sign there. If
Well-
there was, you're saying it might have blown away. So if it would have been blown away, then it wouldn't have been there for 5 days. And that, as you say, sometimes that may happen. So my question is,
If I could answer your question.
sure.
Under state law, we have to either post a property or advertise. Okay, we do both. So if one of the items do not, a sign gets blown down or whatever, we've complied with the other notice. So under state law, this was advertised, duly advertised. So we're not required to post if it's been advertised. So we do both as a protection under state law. So from a procedural point of view, and I'm not debating whether there was a sign there or not, but we advertised, there's an affidavit of posting. I'll leave it up to council to make a legal determination on that. But the issue of whether or not it has been posted, as far as what the code says, it's been met at this point. And you very well may be right that it wasn't there, but the legalities are that it meets what the town code says.
And you got to understand my concern. Now I'm turned into a corner lot, which I don't know if there's any different setback rules before my property. Am I going to have to move my fence? Am I incurring any additional costs? Somebody could have knocked on the door and said, on the opposite side. I mean, that makes sense to me. If I was going to put in a street, I was building a street and say, look, I'm going to be building right next door to you. This is what I plan on doing, blah, blah, blah. No notice was ever made by anybody. And again, not that we're against any of this stuff,
Okay,
but it doesn't seem
okay.
like everything was.
Okay, to be fair, though, there is a paper street that exists. If the board
No, I understand that, yes.
I mean, this was, and so, this is not a surprise. There was always a paper street,
20 years.
yeah, that has been listed there. And a paper street is a proposal for a street to go through.
Correct.
So your lot, when it was laid out and approved by the planning board, was laid out for a corner lot.
Right.
Oh,
No, I understand that.
Okay.
And like I said, I have the original plan that shows the paper street in there. But now I'm wondering, am I going to be held against any new rules or anything for being on a corner lot? is there going to be any protection? Right now, it's, you know, beautifully wooded. We've maintained it. I have shrubbery up along the right side. Are those all going to be knocked down? I don't know what damage is going to be caused right next to my
Well,
home.
let me tell you what you can do if you want, is if you contact the owner of the property yourself, and now that you know that it is there, I'm sure that the owner of the property there is going to try to be a good neighbor.
Right.
It doesn't pay for him not to be a good neighbor. He's got a piece of property to develop, and not having a good neighbor is not the best way to start off.
Right.
So that I'm sure that if you've got something that you're concerned with, or any other person that's with you is concerned about, I'm sure that the owner will try there to accommodate whatever there it is that you feel concerned about.
Now, am I going to be held to any different restrictions now that it is an actual corner piece of property? Or am I grandfathered in that I was on a regular street?
I don't think that all of this map that we have here has been approved by engineering and the highway department for being proper to the original layout there of the paper street. So I don't know what you've done to your property that could be in conflict with that.
No, the planning, for instance, if you live on a corner, I'm sure your fence has to be certain distance away from the street.
Yes.
I don't know the rules. Before this, I was not on a corner. Before this, and then now the road is going to go right along my fence line.
But I mean, you knew that that was going to be a corner property.
No, you don't know which way the road's going to go. It was just a proposed
It's a
street.
paper street,
Yeah, it only went 3 feet onto the, I'll show you the original plans.
but it should have been shown on your deed where this street is going to be.
The street can go really anywhere. They could have went right up the middle of the two pieces. There's no indication of which direction the street's going to go in.
Maybe you can answer his question. The gentleman wants to know, and if you can't, if you can direct him to somebody who can. Apparently, when this is all done, he's going to have a corner lot.
Yes.
Doesn't have one now, even though we know there's a paper street there, there's no street there.
No, he does have a corner one now because the paper street goes partially up his property, so he is a corner lot. What has happened now is the road's being extended further. If you look at the first part of that subdivision, that was already taken into consideration when it was laid out.
But what the gentleman his question is he's now going to have requirements that you have to comply with regarding his fence because he now is on a corner lot.
That's correct. If he has a fence there now, he's grandfathered in.
Okay?
If you have a fence there now, you're grandfathered in.
That's
If
what you
there's a
want to know,
permit
right?
issued for the fence, then you're grandfathered in. If you were to put a new fence where there was no fence, then you're not grandfathered in once the road is built.
Would you get the mic, please, here, and talk to us here so that the recorder there can hear you what you're
sorry.
saying?
But he's always been a corner lot, correct?
Well,
That's
this
when
will give you an
yes.
indication of how the property looks, because it's hard to see what they propose. There's no cut at all for a street right now. So my house is obviously this one on the corner, and this road continues to go right around here. So here's the property line, okay? And it's, as you can see, this street was cut,
But you can see it's
proposed
a
cut.
corner, though.
Well, I understand that, but right now, it's not a corner.
It's just a little
It-
bit,
it was just
now it's
thick.
going to go all the way
I
over
know,
here.
Now
but
it's going to
that's
go all the
because-
way along my fence line.
But that's because they can't take your property. They had a paper street that was laid out with a corner on it where your property is. It just happens that the street doesn't hit into your property down there, that's all.
That's what I'm saying. So what I'm saying is, basically, all the stuff that I have to the house right now is going to be grandfathered in. I'm not going to have any problems with that.
Well,
No,
we know the fence will be.
If you have permits for everything that you have,
Right.
then yes, your things are protected, you're grandfathered in.
Okay.
If you don't have permits, my suggestion is get permits
Go get
before
'em.
the map's filed.
Right. When we put the pool in, we had permits done for the fence, I guess. So,
If you have permits for all the fences and everything, then it remains. It's considered legal and non-conforming.
And what is the setbacks from, because I don't know how to read the maps, what are the setbacks from my property line to the street?
well, right here, it's about 10 feet, right? To the
Oh,
street.
no, when you say setbacks, you mean from the house or? do
No,
you-
from my fence line, my property line to
Well, I
with
don't
new
know where
street.
your property
10
line is.
It's right here on the map.
It's 10
Okay,
feet.
so that's your property line, then there's no problem. In other
No, I'm
words, they're not
asking-
going
I know,
to
what I'm
encroach on
asking-
your
It's
property.
gonna be
I'm sorry,
10
maybe
feet to
I
the
want to be,
curb.
I should got to be
Sir,
clear.
it's
From my
10 feet.
where my fence is, on the other the new guy's property, there's going to be a buffer, I guess, with a street along my
It's
fence
going to be
line
10 feet between
feet.
your
10 feet.
property line and the curb.
and the curb.
Yes.
Okay. I'm just trying to see if I have any other questions. If because the way...
Sir, can you go back to the mic, because what's happening,
I'm
you're
sorry.
not on
They
camera.
told me to come up
right-
here with it.
No, you
Well,
can show that, but...
You had the map, that's
I'm sorry.
what we come up there
Okay,
for.
but you're, believe it or
So-
not, you're on a camera right now
Oh,
when you're
okay.
sitting there.
I'm sorry. So the only other additional question that I have, because it's going to look a little bit ridiculous, my driveway is going to run right along a road. It's not even going to look like it, you know, it's going to be right next to one another, like 10 feet away. You're going to see basically two roads going. It's just not, I don't know how it wasn't like something wasn't done where there's going to be berming or something to differentiate my driveway from the road right next to it.
Well, when you
Wasn't your
filed your
driveway
plan,
inside your fence line?
Oh, yes, it is.
So wouldn't the fence line be something that would differentiate the road from your
No,
driveway?
no, the driveway, I mean, the fence, there's no fence in the front of the property. There's only fence in the back.
Oh, I see, you mean where they first
Where the
start
cut-in,
out?
where the cut-in is going to be, is only going to be 4 or 5 feet from where the beginning, where my entrance for my driveway is going to be. So you're going to drive into my driveway, or drive another 3 feet, and then drive up a street. So my question is, it's going to, aesthetically, it's going to look retarded. It's just not going to look right.
but that was when you had your house built, somebody laid out how your driveway would be, somebody laid out how your house would be, and that was all before this was even applied for.
Right.
So that whatever you did, or whoever did it for you, was done there according to a plan that was given to the town planning department and approved.
Right.
Is that correct?
Well, what I'm saying, it was approved, yes. So, but now this street, again, the street was never there. I maintained it for all these years. How fast do they plan on building in there? Is it going to look like a dump for years? And are they going to berm up or make it aesthetically nice for the neighborhood?
A person is not going to build a house in town, Smithtown now, without making it look nice, because you can't sell the house there without making it look nice.
Right.
Somebody is not going to build a house here for the cost of building a house in this town and do it there and just not going to do it there. It's not going to be saleable,
Right.
okay? They're not going to do something to harm your property, that's for sure. Because they've got to do everything that's away from your property. Whatever is on your property was put there by you or whoever built it for you. And that we can't change,
Right.
because that's what was done there in an approved plan.
Okay. I guess my last question then would be, obviously everything's going to go through and we can't change anything unless I talk to the builder or whoever who's putting in the street, and if they're going to clean up that area. I don't know. It's got 10 feet, but
I'm sure, I mean, you can talk to Mr. Tramarko afterwards.
right.
And he's representing the applicant. And I'm sure that if you sit down and talk with Mr. Tramarko and the applicant, that they're not going to do something that's going to harm either you or them, because they're going to be neighbors to you.
See, we're here to approve this map. As far as, you know, where bushes are going to go and things of what they intend to do, that's another part of the process.
Okay.
But I think what the chairman is saying is correct. Mr. Tramarko is here. You can speak to him when the matter is finished. Maybe he can put you in touch with the builder, and you can sit down and express your concern and find out from the person who's going to actually do it what he's going to do.
Okay, and then the only other concern I have, or if at all possible, to me, again, trying to make everything in the neighborhood look nice, it seems to make sense. If I wanted to, would I be able to go out the other side with my driveway instead of having two roads right next to each other and keeping it all and grassing it over or something like that and making it look?
Well,
If I
again,
could actually-
that's a planning board decision. So that
Highways,
if
right?
you're going
Yeah,
to,
let me- can I
before
ask-
you go do something, you have a You have an application that was given to the planning board for your house and the layout for it. If you're going to do anything before you do anything, if you talk to Mr. DeRubis, I'm sure that at least he'll let you know what he thinks you should do, okay?
Right, well, that's what I'm
Okay.
asking. Would you think
Well,
I
I can
may
answer
be
your
able to do
question if-
something like that?
Yes.
Okay. While the road is under construction, it's a private road, and the developer is responsible for that road. And whether or not he will let you have access to that road is his decision while it's under construction. Once he completes whatever he's doing, and that becomes a public road, you just go down to the highway department and ask for a road opening permit, and the highway department will give you one in this particular case, and you could connect your driveway directly onto this particular road. It's a public road.
If that's the way, I mean.
If
'cause-
that's the way you want it, you could basically request it. And given the fact of this particular location, I think the highway department will approve this in a heartbeat, because it's better than having a driveway right by an intersection.
Well,
So-
that's what my concern was, because it's going to look ridiculous with,
Mm-hmm.
a road right next to the driveway, 10 feet away, running all the way up the side of the property.
We have no problem if you speak to the applicant right now and work out an arrangement with the applicant when they do the construction of this. If you reach a gentleman's agreement, they could put the curb cut in and whatever while they're building the road. That could be between you, the highway department, and the applicant. We have no objections to that. So you could, my suggestion, what the chairman said, is speak to Mr. Tramarko, and when his client puts the curbing in there, have him put a drop curb for your driveway.
Right, okay.
Okay?
That's all I have, thank you.
Okay. Anybody else wishes to speak? Give your name and address, please. And
Donald Sawney, 7 Anne Marie Drive, St. James, New York. I'm a John's neighbor, Anne Marie Drive. C-S-O-R-N-Y. We know the land was purchased about a year or 2 years ago. We were pretty much on top of it. We did call the planning department. They said, look for a sign. When the sign goes up, then you'll know something's in the works. There was never a sign up. I spoke to 10 adults on that court. We see this sign now. There was never another sign up. It's a very small court. So we did call the planning department. They said, just look for the sign. This is the first time I've seen it. I have nothing, I understand this is progress. I have nothing against it. I would just like a little time to look it over. I don't think we're asking too much for 10 days, 20 days, whatever you could give John, myself. I'm looking forward to it. Also, I want to know, I live there. There's going to be a street that may go behind my house eventually. I just want to know what's going on. I feel I've been told nothing. All of a sudden, this is being sort of a rush, and let's get it done. 2 is the guy who built it was Glen Hill Estates, Jürgen Fiji. He was supposed to buy all that land. Somebody backed out at the last second. He couldn't build it. There may or may not have ever been a street put in there. Mr. Danigella spent a lot of money on his house. He's a great neighbor. I think somebody owes him something. You're going to turn around and tell this guy spent $200,000 on landscaping. It's too bad. I mean, he needs some notice. We're not against progress. I'm sure this guy over here who's doing it is a great guy. All we want is give us a few days to look at it.
well, the thing is that we've had a preliminary hearing already, and I know that you said it wasn't posted, but we have the affidavit that it was posted, and that's what we made.
So what if we bring people down here? If we could test, go ahead.
Excuse me. And that's what we made a preliminary hearing approval on. Now we're at the final map. And the only thing that's on the map is just the location of the houses and the driveway. Nothing else is on there. No landscaping, no anything. Not even what the house is going to be, because that's still got to be laid out there by the planning department. So this is not a process that's going to be done here tonight. This is a process that's going to take some time to be able to finalize. But it's already been heard once, and this is the final map.
So we live on that court. We lived there for 20 years, and
Yes.
we had no idea until about a week ago this was going to happen. I think there's something
Yes,
wrong
he
with
does.
I think there's
Yes.
something wrong. Please don't interrupt me. I think there's something wrong with the system if that's the way it's going. We lived there. There should have been a sign. I think it was sort of done without anybody knowing on that whole court. It's a beautiful court if you've ever been there. They're all nice homes. We'd like to know what's going on. That's all we really ask for.
And I don't think that anybody's going to take that away from you.
And what happens, like John said, if they that Georgetown Estates, which is right down the block from us, they put a street in, there's no homes on them right now.
Yes, but you can't, but listen, if it's a paper street and laid out, and is part of the plan from the planning department, and been there for years, you can't stop somebody from developing their property. You can
Okay,
get people there to conform to whatever it is there that the rules, but you can't stop them from developing the property.
Is there a lawyer here tonight for the town?
The what?
Is that the lawyer for the town?
No, he's.
No, he's a lawyer for the board.
There's no lawyer here for the town.
You can go to the town if you want to go to the town attorney.
Okay,
Yes,
okay.
okay?
All right, so
But
so
we
can-
haven't-
can
we haven't
can
done anything.
Is there any way we can stop?
Well,
I'm
we
not
haven't
looking to
done
stop the
anything.
guy from building it. All we want to know is what, we want like 20 or 30 days to look it over.
Well, that's not the case here that we have here tonight.
See, we're just approving the subdivision of the property and the locations of the houses. And that's,
I find it very odd that all those homes, not one of us knew this was going to happen.
The what?
None of us on this Amory Drive, there's like 9 homes there, not one person on Amory Drive knew that this was going to happen until like a week ago.
Well, they may not have known, but like Mr. DeRuba said, first of all, it was advertised in the paper, which is the first thing they have to do. Then they do the posting.
There was no posting on Amory Drive.
Listen,
I
didn't say that there was or there wasn't. I'm saying we have an affidavit that they were posted.
where,
Okay.
on what locations? Can I see the locations where they were posted?
Well, I don't know.
I would like to see it, please.
Again, there's something there that you'll have to look at the record for in order to do it. We don't have that. It's in a file here that we just looked at, but we
But
don't
what
have
happens if
it.
it's not true? What happens if they weren't
You
posted?
can go down to Mr. DeRubis, and he'll show you the affidavit of the posting.
let him show him now. We have it.
Yes?
Statute requires a posting on the public roadway. Anne Marie Drive is not a public road.
And that's maybe the
Nestor-
reason that it wasn't
Nestor
done on a
Drive
public
is not a public
roadway,
roadway.
okay?
So it wasn't posted on,
But it doesn't have to be.
Doesn't have to be.
I'm not, so then you answered the question.
Right. In other words, according to council, it has to be, the sign has to be posted on a public roadway.
Abutting the property.
Esther Drive was not a public roadway.
But Anne Marie Drive is a public roadway. Why wasn't it posted on Anne Marie?
The property doesn't touch the property.
The property
It-
doesn't touch Anne Marie. Property is between Lake and Esther, so most likely, it was probably posted facing out onto Lake.
That's where it was posted. That's what I saw.
And legal
posted.
counsel will say that's legitimate, that it didn't have to be posted on Anne Marie Drive. The lawyer from Smithtown is going to say, we only had to put it on Lake. We didn't, I want to speak, the
It
lawyer's
has to
going to
be on
say,
the, it has to be on the, as far as I understand, it has to be on the property itself.
I think it has to be on Anne Marie also,
Based on what?
based on, I've done it before in the town of Smith and St. James.
Okay.
Well, listen, we're dealing with a map here tonight, okay? And we've already had a preliminary,
So I would like you to
and
ask
we've
the
had a
lawyer.
wait a minute, excuse me, I'm talking.
Go ahead.
And we're gonna go by the record that we have for the recommendation from the engineering department, the highway department, and from the planning director. We're not going to start there legislating there what you or what somebody else wants. We're gonna do what we have to do there as a planning board. And our job is either to approve the plan, which we did for the preliminary, or approve this plan, which we are gonna consider here tonight. And that's what we're gonna do. And if you have any difference with that, then you do have a right to go to the town attorney or go to Mr. DeRubis or someone and try to do it. But we're not going there to change what he has on his property, or you like on his property, or you don't like on his property. That's not our business. Our business is to handle the map, and that's all. Okay?
Are you finished? Thank you.
See, this is a big process, and what's here tonight is the map, subdivision, and where the houses are going to be. So a lot of these other questions that people have may be very legitimate, but it's not going to be dealt with here.
Okay, thanks.
Okay? Anybody else wishes to speak? Yes. Give your name and address, please.
Jeremy Hackett, 12 Anne Marie Drive. I just actually, like them on the block, haven't heard about it and want to see the map just to see what's going on. So
It's right there, yep.
That's what I'm here to do. Just a quick question to follow up sort of what they were saying, though. I know the house next to me was vacant land. It was developed last year, but I was notified via letter, certified mail. I'm surprised I didn't get one on. Is it not required? No.
No.
Okay.
If you were notified, it was probably because there was a variance that was necessary on the property. This is a subdivision, and there's a different requirement under state law for posting and noticing.
Okay.
Okay.
So Frank, the whole issue, I mean, the issue with the posting is that the requirement was fulfilled because it was posted on a public roadway, and the property abuts that public roadway and not on Anne Marie Drive, correct?
That's correct.
That's why the posting was done on Lake Avenue.
Yes. I believe Blaze was the one who gave out the signs, and I believe he probably felt it was prudent. We normally are conservative and are prudent and give it out wherever we possibly can. It's a paper.
Right, Esther was a paper street, but Anne Marie did not abut the property. So we had to do the requirement of the subdivision regulations, correct, with the posting?
The minimum requirement is to be posted on Lake Avenue. That's
Okay,
it.
and we also advertised it, correct?
That's correct.
So we went on and above the minimum.
We did.
By doing the advertising, and we also fulfilled the requirement of the public roadway.
That's correct.
Okay, thank you.
Another question.
And I'm sure there, if you gentlemen would contact Mr. Tramarko and the applicant, they're not going to do something that's going to hurt your properties. It doesn't pay them to do something to hurt your properties. It's to their advantage to make sure that what they do to the property is an improvement there for everybody.
I'm sorry, John Danigelis again. I guess you had to know. And that's what our point is, because being that we didn't know that there was a posting going on, or, you know, Jeremy got a nice letter saying, we plan on doing this, the first time we saw was people marking the trees. My wife called the town, and they said, oh, it's, you know, months off, nothing, you know, nothing's in the works now. She called right away as soon as she saw people in the woods. We want to know what's going on. Nothing, you know, mark some trees and do whatever, but, you know, again, Esther Drive, the paper road, that was on my plan from the beginning 20 years ago, I know that. That wasn't a public road, but it's a paper road that was on paper, so I think that the sign should have been posted where it's going to affect most people, not the people that it's not going to affect. The posting on Lake Avenue is not affecting anybody on Lake Avenue. The only people that it's affecting, and I'm not saying it's a negative effect, and I just want to get the point across, is that we don't think it was done right, basically, is where we're at with it. And the posting should have been where it is today. Why wasn't this sign put on, you know, on Lake Avenue again? You see what I'm saying? So it kind of seems underhanded. So, and you want me to talk to the builder.
What would change if we didn't approve this map tonight?
No, no,
what would change about what you have done to your property?
I'm not saying what's
We
going to...
can't do anything about that. All we can do is approve this application that's been before the planning board twice, once as a preliminary and now as a final, and look at the layout there for the houses. And that's all they are, is a layout for the houses. That's all.
Correct.
Nothing else, no landscaping, nothing. And then as this goes along, the engineering and everybody is going to get involved. And if you stay in contact with Mr. Tramarko and the owner, I'm sure that they're going to do something there that's not going to hurt your property.
And I understand you, Mr. G. Let me just finish for one more second. What I'm saying is you're saying you're sure.
I'm sure of it.
Oh, you're sure of it. But I'm saying why wasn't the sign posted so we would have known, and then it would have been a happier meeting tonight. It would have been not that we're against it again. If it would have been posted there, then I would have been sure.
But
You're sure, but I'm not sure.
But what could I change tonight?
You can't
If
change
it was-
anything tonight. You just have to listen to me talk.
No, because
That's it.
I can listen to what you have to say, but I can't change anything on your property.
I know that.
I can't change where your fence is. I can't change where your
I
driveway is.
understand that. Maybe they're changing the process. Maybe somebody else gets that sign on their street, and I did a service for the town. I don't know what I'm talking about.
Excuse me, sir. So far you had two remarks. One, you mentioned something was underhanded, and now you came up with that remark. If I would kindly, insist that you keep your comments in regards to the map. Now, from what I understand, I've asked Mr. DeRubius the same question. Did we meet the requirements of the posting?
Right.
And the answer was yes. Did we go through the process of also advertising? Yes. So we met the requirements.
Okay, that's fine.
The property was posted. This is a map for final approval.
Okay.
The overall final workings are not what we're discussing at this moment.
And who...
So,
I'm sorry, go ahead.
sir, so if we could just try to just bring the conversation to what we are talking about with the map.
Okay, and when does the so I know, when does that other part happen?
Well, that's a process. Frank, maybe?
What is going to happen this evening is what is called a conditional final approval. You have about 9 more months to this is actually approved. In between that period of time, the applicant will then have to submit a performance bond that guarantees, that's like an insurance policy in the town to guarantee any public improvements. They have to pay their proper park fees and other fees that are associated with this. They have to prepare a new map designed for filing in Riverhead, which has to be reviewed by my office, and it has to be distributed to a number of agencies so that they are aware that this has been conditionally approved by the board. When all of those conditions have been met, I then bring back the board, like I just brought earlier, this map here was a previously approved map. The chairman then signs it, and then when it's filed in Riverhead, that's when it becomes official. So tonight's action is what we call conditional final approval. You're about 9 months away from final approval.
Okay. Now, I'm sorry if I, offended you, but, they were saying that I should just take their word on him being able to talk to me about what they're going to do, and I was just trying to, maybe I didn't say it the right way, and I apologize if you took it the wrong way.
Okay, no offense. What we try to do as a board is take the map that's been worked through there by the planning department, because we don't have anything to do with the actual laying out of this. All we do there is look at what the planning department and the engineering department and the highway department go through in the process to get it this far. It's got nothing to do with what the house is going to look like when it's finished.
Right.
Okay? And that's the part that people are on. Certainly there, if the attorney and the applicant are not going to do something that's going to be offensive there. They
Right.
got to live there.
Okay, great.
Okay?
Thank you very much.
There's one last item, Mr. Chairman, if I could just add for the gentleman's consideration. When the map is finally approved and construction begins, the applicant has to put down a cash deposit as well as he pays for an inspector to go up to his property. There's an engineering inspector. One of the responsibilities of the engineering inspector is to protect adjacent properties. If there's any damage or anything that is caused to adjacent properties, even if it's minor, the engineer on who's ever assigned to that particular task will order that it be fixed. If it is not fixed, we have the cash on hand to repair that. So if there's some concern of yours why this is under construction, you speak to the engineering department and the inspector will note if there's anything of particular importance to you. And that includes such things as making sure the site is watered down while the construction is going on so there's no dust that's going into your home or pool or anything else like that. So those are, we take our construction very seriously in this town, and you do have a right to contact the engineering department who maintains the site in an acceptable manner. Okay?
Okay, anybody else? All right. A motion there on the final map for Esther Estates.
In the matter of the final plat of Esther Estates number 1144, I move that we adopt the resolution as read in accordance with the recommendations of the planning department.
Second?
Second.
All those in favor?
Aye.
Aye.
Aye. Opposed? So ordered. On the request for the building zone ordinance, the modifications. Motion on the modifications.
In the matter of Esther Estates number 1144, motion to approve the variances as listed in the table of modifications.
Second?
Second.
All those in favor?
Aye.
Aye.
Opposed? So ordered. On the performance bond fund.
Mr. Chairman, we have the performance bond. The following resolution is suggested for the board's consideration. Be it resolved that the chairman of the planning board be authorized to sign the performance bond and estimate for the map of Esther Estates, case number 1144, in the amount of $81,260 and establishing an inspection fee of $6,500 and a cash deposit of $3,000. Therefore, the amount of the performance bond to be posted with the town shall be $78,260.
Motion on the performance bond.
In the matter of Esther Estates number 1144, Motion to approve the performance bond estimate as recommended by the Planning Department.
Second.
All those in favor?
Aye.
Aye. Opposed? So ordered. We thank you.
Okay,
And
Mr.
be sure there and contact Mr. Tramarko and Mr. DeRubis, and they'll keep you up to date on everything. Okay?
Owners are here tonight. We'd be happy to speak to these gentlemen. if
Okay.
they wish to speak.
If you go outside there, and you can talk to them outside in the hallway, where any questions that you have there will be answered by him.
Mr. Chairman, we have already signed the map of the performance bond and the subdivision map, so therefore, there's no other items on tonight's agenda, and we recommend adjournment.
What is the Brent? What is the Brent at the bottom?
Brent is a transfer of development rights.
Is what?
That's a TDR. That's adjourned.
What is it, been adjourned?
Yeah, it's been adjourned.
Okay. All right.
So we can adjourn.
Motion to adjourn.
Second.
All those in favor?
Aye.
Opposed? So ordered.